All right, I call cause number 10,845. The case is styled State of Texas versus Skylar Halen Holman. We are about to conduct a plea hearing wherein the defendant indicates that he desires to enter a plea of guilty to the charges in the indictment pursuant to a plea agreement. This hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. This hearing is also being live streamed on the court's YouTube channel. Both electronic avenues are being conducted in this manner in order to comply with the Texas Supreme Court orders, as well as rules and directives from the Office of Court Administration. Since these matters are being conducted in this fashion, the court notifies all parties or participants, including those who may be just observing by YouTube, that all persons are expressly prohibited from recording this proceeding in any manner using electronic means, photographic means, or the record functions of Zoom or YouTube. To violate this order could result in someone being held in contempt of court. The prohibition has one exception. That one exception is the official court reporter for the court, who is in fact recording this proceeding just like he would do so in a open court in-person hearing. Those announcements out of the way, for purposes of this hearing, this plea hearing, what says the state?
Ready, Your Honor.
And defense?
Your Honor, ready, but there's something I'd like to note at the outset, and that is Mr. Holman has signed his application for probation indicating he's never been convicted of a felony. I believe that to be the case, but there's a bit of a caveat. Mr. Holman isn't exactly sure, so I studied his DPS criminal history, and it appears that in Travis County he was charged with a felony, but it was reduced to penalty group 2, less than 1 gram, and further reduced to attempt, which, although the history itself reflects state jail felony, the degree of offense indicated is Class A misdemeanor. I don't think it was a 1244A. If it was attempt to commit a state jail felony, I believe it was a Class A misdemeanor. So we believe we are accurate and truthful when we represent that Mr. Holman has not been convicted of a felony. So, having noted that, Your Honor, we are ready.
All right. Mr. Holman, for purposes of the record, are you Skylar Halen Holman?
Yes.
Am I pronouncing your name correctly?
Yes.
Mr. Holman, an indictment has been returned into this court charging you with possession of a controlled substance, which, as alleged, would be a second-degree felony. You have the right to have someone read that indictment out loud to you here in court. Do you wish to have someone read the indictment out loud to you?
No, sir.
Is that because you already understand that the indictment charges you with a second-degree felony offense of possession of a controlled substance?
Yes.
Understanding the charge in that indictment, to that charge, how do you wish to plead? Guilty or not guilty?
Guilty, Your Honor.
Do you understand that you that you have the right to enter a plea of not guilty. And further, you have the right to not have it held against you or used against you just because you might exercise your right. Do you understand that?
Yes.
You also have the right to have a minimum of 10 days notice of your charges. And you have had more than 10 days notice. So I would tell you that I would grant to you some additional time to prepare for trial if you desired to have that additional trial or additional time. We do have a jury called for next week. And so I would grant to you the additional time to prepare for that trial if that's what you wanted. Do you understand that?
Yes.
You also have the right to have a jury hear your case. And that's true even if you enter a plea of guilty to that charge. Do you understand you have the right to a jury trial?
Yes, sir.
Now, I've been handed a document entitled Waiver of Defendant, which has a signature on it that is just like the signature on the stipulation of evidence that the notary public went over with you. Did you sign a document entitled Waiver of Defendant?
Yes.
And did you know that that document said that you're giving up the right to or the opportunity to have more time to prepare, and you're giving up the right to a jury trial?
Yes.
Is that what you still wish to do?
Yes.
Mr. Keith, your signature is on this document as well. Are you joining your client in these waivers?
Yes, Your Honor.
And Mr. Smith, your signature is also on the document. Is that evidencing the state's joinder in the waiver of the right to a jury trial?
It is, Your Honor.
All right, I will accept those waivers and we will proceed. Mr. Hallman, there are other rights and admonitions I need to discuss with you. Let me start by discussing the range of penalties for the offense charged in this indictment. As we've mentioned a couple of times, the indictment charges a second-degree felony, and the range of penalties for a second-degree felony runs from not less than 2 years to not more than 20 years in the Texas Department of Criminal Justice. It also carries the possibility that a fine could be imposed, and if imposed, it could be in any amount not exceeding $10,000. Do you understand that's the possible range of penalties you face under the indictment in this case?
Yes.
I have mentioned a couple of times that I understand there is a plea agreement in your case. I tell you now, I do not have to follow the plea agreement. I do have to tell you if I'm going to follow the plea agreement or not, because if I decide not to follow the plea agreement, the law would then recognize a right in your favor, allowing you to withdraw your plea of guilty. Stated hopefully a bit more simply, if I don't follow your plea agreement, you have the right to take back your plea of guilty. And if that occurs, we just start all over. And nothing you have said today or signed for today's proceeding would be used against you or held against you when we then did go to trial. Now, that's what happens if I don't accept your plea agreement. So what happens if I do accept your plea agreement? If I accept your plea agreement, you will be bound by the terms of that plea agreement. You will not be able to get out of its terms if I follow them, just because you don't like them anymore. You can't even change your mind after the fact and say, I don't want to do this anymore. Once I accept your plea agreement, the terms of that plea agreement are set. You can't even get out of the terms of the plea agreement if I follow the plea agreement by appealing your case. Now, that's contrary to the norm. The norm says everybody has the right to appeal. So how do I say the norm might not apply? The law says if a person waives or gives up the right to appeal as a part of the plea agreement itself, that term also is a part of the agreement and is to be complied with. So that means, and I've looked at your plea agreement, that term saying you give up the right to appeal is a part of your plea agreement. And so if I follow your plea agreement, you literally will not be able to appeal. Do you understand that?
Yes.
All right, then let's go further with the discussion of your plea. And so let me ask some questions I'm required by law, by statute, and even by case law to ask. The first one is, are you a citizen of the United States of America?
Yes.
Where were you born?
Amarillo, Texas.
Almost Canada, huh? So that explains how you were able to drive through all of these conditions to get here today, I take it. Let's put this humor aside, and I apologize for leading us down a humorous trail. My next question asks, do you consider yourself presently to be mentally competent?
Yes.
Do you know what's going on in these proceedings?
Yes.
Have you been able to understand the charges against you so that you could discuss not only those charges, but also the facts that sort of surround those charges and discuss them and cooperate with your attorney in determining how you would proceed to meet these charges? And to some extent, not to some extent, to a large extent, that also includes, have you been able to hear and understand what your attorney advises you with respect to what the law is and how the law affects, or maybe even is affected by the facts of your case? Have you been able to do those things?
Yes, sir.
Mr. Keith, do you believe your client is mentally competent?
I do, Your Honor.
I accept that representation, and it's fairly evident that Mr. Holman is mentally competent, and so I make that finding that he is. Mr. Holman, my next question asks, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, sir.
Let me tell you why I asked that question, because I'm not trying to suggest that you shouldn't be satisfied or wouldn't be satisfied with his assistance. I asked the question instead just to give you the chance to tell me if for some reason you were not satisfied, you thought his work might be deficient or legally ineffective. If that were the case, my question gives you the opportunity to answer and tell me that that's the problem, that there is a problem. And if a problem such as that existed, then I would make every effort to eliminate any such deficiency or legal ineffectiveness and resolve any problem that might exist. And that's why I asked that question, just so you could tell me and we could work on it if a problem existed. But let me also tell you that since I have given you the opportunity to let me know if a problem existed so we could get it corrected, if it existed, that necessarily means you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job. In other words, now is the time to tell me if such a situation exists or a thought exists in your mind. Do you understand that?
Yes, sir.
And understanding that, are you still telling me you're satisfied with the legal representation you received in these matters?
Yes, sir, I am.
All right, my next question goes to a little bit different area. I'm also required by law to be satisfied that the decision to enter this plea of guilty is your decision, that it is freely and voluntarily entered into by you. And so I ask you a few more questions to help me determine that. First, has anybody threatened you or forced you or tricked you or in any way tried to make you enter a plea of guilty when you would not otherwise do so?
No, sir.
Has anyone promised that you would get something of value, some benefit, money or other benefit just to get you to plead guilty when you would not otherwise do so?
No, sir.
Are you telling me then that you're entering a plea of guilty to this charge because the truth is you are guilty of this charge, and that's the only reason you would plead guilty to such a charge?
Yes, sir.
All right, so those are all the questions I have at this moment. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
No objection, Your Honor.
Mr. Holman, the district attorney has offered that document that the notary public discussed with you. It's entitled Stipulation of Evidence, and I want to talk to you about some other rights and to give you some more admonitions. Some of these seem most germane at this moment in time. And so I start out by telling you the state is required to produce some evidence tending to show your guilt, even though you're pleading guilty. I've always believed and still do that that's a part of our law because it helps to ensure that another right that belongs to you is in fact provided to you. That right is your right to see and hear the testimony of any witnesses who might testify adverse to your interests. We call that right the right to confront the witnesses against you. And as I mentioned, that really just means you have the right to see those witnesses and hear those witnesses as they testify. But this stipulation of evidence says you're giving up that right, and thus you're telling the district attorney that and this court that the district attorney doesn't have to bring his witnesses into court at all. Did you realize you were thus giving up the right to confront the witnesses against you by signing the stipulation?
Yes.
The stipulation also says you're giving up your right to remain silent, as well as your right to be free from self-incrimination. And the right to be free from self-incrimination is the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself because the stipulation says it is a judicial confession, and you are admitting that all of the material allegations set out in that indictment are true. That is, you committed the offense just like it is alleged in the indictment. Did you realize by signing the stipulation of evidence that you were admitting to the commission of this second-degree felony offense?
Yes.
There's another paragraph in the indictment that says you stipulate that you owe court costs in this case in the sum of $290, that there will be restitution obligated in the sum of $180, and that there will be reimbursement fees assessed against you in the sum of $675. Did you realize that paragraph discussing those matters was in the stipulation when you signed it?
Yes.
All right, sir. Then State's Exhibit 1, the signed sworn stipulation of evidence, is received as evidence in your case.
State rest, Your Honor.
Defense rests, Your Honor.
Mr. Holman, sorry.
State closes.
Close.
Mr. Holman, let me discuss with you the plea bargain agreement itself, just to make sure that I understand it the same way you understand it. I understand it to say that you will enter a plea of guilty to this charge as you have done so. Further, it says that you will be sentenced to the penitentiary for a period of 5 years, but that sentence to the penitentiary will be probated for a period of 5 years, provided you follow all the rules of probation. The plea agreement also says that there will be a fine assessed in the sum of $1,500, court cost obligated or assessed in the sum of $290, and reimbursement fees being obligated for your payment in the sum of $675. And further, that there would be a restitution obligation in the amount of $180. The plea agreement also says you're giving up your right to appeal, but I've already discussed that with you. And then it says you will participate in what we call a TAP program, which stands for Treatment Alternatives to Incarceration. And it is initially an assessment followed by, based upon the assessment, a treatment or counseling plan if that's needed or indicated by the assessment. Now, all of that is my understanding of the plea agreement in your case. Is that the same as your understanding of the plea agreement?
Yes.
And are you asking me to approve this plea bargain agreement?
Yes, sir.
Mr. Keith, have I stated the plea agreement accurately as you understand it to exist?
You have, Your Honor.
Mr. Smith, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
All right. Mr. Holman, I announce that I will accept and follow your plea agreement. And so I announce in cause number 10,845 for the case style, the state of Texas versus Skylar Halen Holman, that based upon your plea of guilty and the evidence you stipulated to, Mr. Holman, that you are guilty of the offense charged in the indictment, namely possession of a controlled substance in an amount that would make this a second-degree felony. Having made that adjudication and announcement, let me ask, do you know of any legal reason why a sentence should not be pronounced at this time?
No, sir.
All right. Then following your plea agreement, I hereby sentence you to serve 5 years confinement in the Texas Department of Criminal Justice, the Institutional Division. I order you to pay court costs in the sum of $290. I assess a fine totaling $1,500. I order you to pay reimbursement fees totaling $675 and to pay restitution as a term and condition of probation, which I also impose so that you will be, and I order you to be placed on probation for a period of 5 years, provided you follow all the rules of probation. So let me start there by asking you, one, are you familiar with the rules of probation you will be expected to follow?
Yes.
Can you follow these rules of probation?
Yes.
Will you follow these rules of probation?
Yes.
And I ask it that way because if you cannot or will not follow the rules of probation, then you're not likely to stay on probation. And you would be wasting your time, maybe even others' time, if you're not going to follow those rules of probation. Now, let me ask you another question that I ask solely for the purpose of the record, although it's obvious the answer. That question is, are you able to read and write the English language?
Yes.
And I ask that question for the record because by doing so, I'm confident that you can read the rules themselves as frequently, as often as you wish, so that you will never be able to say, I didn't know that was one of the rules. You'll be able to read them. We will make a copy of the rules available to you when you report across the street to the probation office. Now, since you are able to read and write the English language, I also am not going to read these rules to you, since, as we've already established, you can read them yourself. But I am going to mention some of them for emphasis, just because these are the rules I see that most frequently cause some of our probationers to have their probation revoked. That's not our goal. Our goal is for you to satisfactorily complete the rules of probation. But rest assured, if you don't, your rules could be revoked and you could be sent to the penitentiary. First rule I would mention for emphasis is don't break the law, not here or anywhere else. You cannot expect to stay on probation if you're out there breaking the law. Next, stay away from drugs and alcohol in any form. Don't go to places where drugs or alcohol are sold, served, consumed, or possessed. Now, this obviously is a drug case, a drug-related case. And from the discussion that your attorney presented to us, this may not be the first time you have encountered charges over drugs. You need to plan on putting that out of your mind and out of your system while you're on probation. Otherwise, it can result in your probation being revoked. Do you understand that?
Yes.
All right. The rule is a bit expansive, and I expand it to say, don't go into places where drugs or alcohol are sold, served, consumed, or possessed. There are some exceptions, such as a grocery store. You can go into a grocery store even though they sell alcohol. Likewise, you may go into a convenience store, even though they sell alcohol there. It's where a lot of people get fuel for their vehicles. So you can go in for other purposes in a grocery store or a convenience store, but you cannot purchase, possess, or consume the alcohol while there. Do you understand that?
Yes.
All right. You can also go into a restaurant. I make that exception because not every restaurant that sells alcohol tells you out front that they're selling alcohol. So I make the exception that you can go into the restaurant just so you're not feeling that you got trapped into violating your probation. That's not our intention. But if you go into a restaurant and find out that they're selling alcohol, you just have to be careful that you do not possess, consume, purchase, or have anything to do with the alcohol or anybody else that's there, maybe even in your party, that is not having to comply with that sort of rule. Your financial obligations on probation total $2,645. That includes the fine, the court costs, the restitution amount, and the reimbursement fees that I've already discussed with you earlier in this plea discussion. There is a suggestion that you want to pay your fine, cost, reimbursement fees, restitution, and such on a monthly basis, and to do so at the rate of $45 per month. Is that your request?
Yes.
And I need to make sure I understand that clearly, and so I'll ask a couple more questions. One, do you understand that there is an additional $60 per month court supervision fee that you will have to pay each month? And those two together total $105.
Yes.
Do you have the ability to earn funds that would allow you to make those payments and still take care of your physical needs and the needs of any relatives, dependents, as well as yourself? Do you have the funds to do that?
Yes.
Or the income to do that? I'm sorry, do you have the income to do that?
Yes.
All right. Then I will permit that and make it a term of your probation. So the two together total $105 each month, starting with this next month, you'll make your payments on or before the 5th day of each month. Now, another rule of probation is that you report to the probation office here in Snyder, Texas, and report there every month. But it's my understanding, and some of the material presented to me says you live in another planet. It must be another planet. I can't read the handwriting. What is that address?
It's 1204 Montel Lane in Hutto, Texas.
Hutto.
Hutto. Is that Hutto?
Yes.
No criticism intended. It looks like Autto. So I'm going to try to make that a little clearer. So it says Hutto, Texas. And the street address 1204, is that Mondale?
Montel Lane.
Spell Mondale.
It's Montell.
Is that in Travis County, or is that south of Travis County?
It should be Travis County.
Okay. I say south, it may be southwest. All right. You will continue to live at that address. You will not move from there without permission from your probation officers. But that's not difficult to obtain. They're not trying to keep you from moving. They just want to know where you're going to be while you're on probation, and to make sure you're not moving into some place that would cause your probation to be in jeopardy. And with you residing in Travis County, if it is in fact Travis County, whatever county you actually reside in, we will attempt to transfer your probation to that county. Now, they have to approve you living in their county on probation, but generally that's fairly simply accomplished. Once we get your case transferred to Travis County, or whatever county you reside in, you will report in person to a probation officer there. And then you will report by mail to a probation officer in Snyder as well. So living in another county, you have two reports, one in person and one by mail. We will give you forms to report on, to use to make your report by mail. You can send your monthly payments with your written report. You're not required to, but you may. Today, let's see, it's 3:25, 3:26. Today, you will report to the probation department, and they will discuss briefly with you your reporting obligations and how you go about doing those sorts of things. By the way, be sure that you make your written report in person every month so that it gets here before the 5th day of the month. While on probation, you will perform community service, and you will do a minimum of 10 hours per month of community service. You may do that down in your home county. You don't have to do the community service here. If you are in a situation where you qualify to pay for your community service, those payments would have to be made here, and your probation officer would discuss that with you if that's a provision that is beneficial to you. While on probation, you will observe a curfew. I've already mentioned you'll not leave your home county for more than 3 days. Do you have a high school diploma?
Yes.
You will furnish a copy of that to your probation department. You will observe a curfew while on probation and not be out past 10 o'clock at night. Let's see. Bless you. You will come back to see me for a probation performance review on the 13th day of May. That's a Thursday afternoon, and I have 2 sessions, one in the morning at 9:30, the other in the afternoon at 1:30. I will give you your choice of which session to attend. What is your preference?
The 1:30 is fine.
All right, you will report at 1:30 on that date unless we're still in COVID restriction timeframes, and if so, we will schedule a specific time during the day for you to appear so that so that everybody can socially distance. Now, these are not all the rules of probation. There are other rules, and you will have to comply with all of them. Do you have any questions about any of the rules of probation that you went over with your attorney about, or that you read in these documents?
No.
All right, so those will be the rules and orders of the court. Your thumbprint will be required on the judgment. It actually is now on the judgment. You will go to the adult probation office as soon as you leave the law enforcement center there, as soon as this plea discussion is over. And they will have copies of these documents for you. Anything further from state or defense?
Nothing from the state, Your Honor.
One thing I'd like to note while we're on the record, Your Honor, I haven't expressly discussed this with Mr. Smith, but I've taken it for granted. I'd asked that he confirm that I was correct to do so, but I told Mr. Holman that, especially in consideration of his appearance today, that he would not be facing a further charge of failure to appear based on Mr. Holman's non-appearance for court last week.
That's correct, Judge. Your Mr. Keith.
All right. Thank you. That's all from the defense, Your Honor.
I think that's the first time anybody ever came close to confusing the court with Mr. Keith. All right, Mr. Holman, how did you manage to navigate the roads during this weather? Did you come in today or yesterday?
I came in this morning, actually. Yeah,
Now-
I left my house at like 7 o'clock or something.
Where was the most difficulty travel-wise?
It was probably from the moment I left my house up until I got to Brownwood, and then it kind of like the main highways, I guess, started coming in. So they weren't as frozen over, but it was like still pretty bad up until that point.
Based on the charge that you entered a plea of guilty to, there were some who thought you may have flown in.
No.
Good. So let's don't ever have that comment or discussion any further.
Okay.
All right. Good luck to you, sir. I will see you in May. The probation performance reviews are just a time where I check to see how somebody's doing on probation.
Okay.
It's not an adversary hearing. We will check to see how you're doing. If you're doing everything you're supposed to do, we will say, good, that's what you're supposed to do. If you're not doing everything you're supposed to do, we will try to help you readjust what you're doing. Again, our purpose is to see that you successfully complete your probation. Sometimes that may mean the adjustments may not be pleasant,
Right.
but please don't misunderstand me. I don't want you to think that, oh, you don't have to worry because they're just going to help me adjust. Ask anybody about the reputation of this court. And if you don't make an effort to succeed on probation, then we can't help you. And your probation will probably get revoked.